Hello friends, welcome to our informational series. Today we are going to talk about Prevention of Money Laundering Act or PMLA as it is generally known. Money laundering is the process of making money generated by certain crimes to appear to have come from legitimate source. Typically the people try to cover the proceeds of crime by doing a series of transactions so that the origins of the money cannot be traced back to the crimes. During the series of such transactions, the money is slowly shown as genuine income and even taxes are paid. Thus the term money laundering. These monies finally stay invested in the form of purchased properties or other legal investments. It is important to note that only incomes from certain criminal activities are considered under the Money Laundering Act. The Act lists the provisions under different acts that are considered under the scope of money laundering activities. The idea behind anti-money laundering law is to make sure no one earning from such criminal activities is able to enjoy the proceeds of such crime. The Act ensures that the money laundering activities lead to attachment of such properties so earned, and in case such properties cannot be attached, then money equivalent of such properties may be attached. Freeze or seizure of such assets which are in the banks or in the form other than physical properties. Act also empowers the Enforcement Directorate to search and even arrest accused while investigating the offences of money laundering. The Act provides for rigorous imprisonment from 3 years to 7 years along with fine for committing the crime of money laundering. The punishment and the fine under the Act are in addition to the punishment or fine accused may be awarded for actual offence he committed. The person who was not involved in actual crime but has participated in the act of money laundering is also covered under the Act. The remedies under the Act fall in two categories and the proceedings are held before two different authorities, the Adjudicating Authority and the Special Court. Let us look at each of them. Adjudication takes place before the Adjudication Authority and is for confirmation of attachments, seizures or freeze done by the Enforcement Directorate. Typically, the wheels of justice are set to roll by Enforcement Directorate or ED as it is called when it usually comes to know or is informed of about the occurrence of specified offences under the PMLA Act by different government investigation agencies like police, SFIO, etc. Based on the information, ED will start its own independent investigation. During the investigation, if ED comes to realize that the money laundering activity has taken place and any property has been purchased or investments made out of the proceeds of scheduled crimes, it will typically issue an order of attachment, freeze or seizure of such property. Once ED has made such an order, it will within 30 days of issuing such order submit a formal complaint along with all relied upon documents to the Adjudicating Authority. This complaint is called Original Complaint or OC. It is to be noted that ED can attach such properties even if such property has changed hands, and ED feels that current owner is involved in helping out the money laundering activities or is just a front face for the accused. On receiving the complaint, the Adjudicating Authority will issue notice to all such persons whose properties have been attached along with accused to show sources or means used in acquiring such properties and reason as to why attachment order should not be confirmed. The respondents must file their response within specified time along with the proofs and justifications. The hearing is held before the Adjudicating Authority. After hearing both the sides, Adjudicating Authority will either confirm the attachments or retentions of properties in question or release them. Once the attachment is confirmed, ED is free to take possession of such properties and if it is not practical to do so, then confiscate it under its authority. Once the property has been confirmed, it will remain with the ED till the conclusion of the criminal trial. It is only after the criminal trial is over that the final confiscation to the central government will take place. However, meanwhile, any of the aggrieved parties have option to appeal before the appellate authority within the stipulated time. Now let us see how the criminal trial takes place under PMLA. As soon as ED receives an information about the scheduled offence under the Act, it usually puts it in the form of Enforcement Case Information Report or ECIR as it is called. ED then starts investigation. During investigation, it has all the powers as a police officer has while investigating any case. ED has the power to survey, search, seize, or even arrest the accused if it has reasons for same. It can issue notice to witnesses or accused and question them. The statements given to ED have to be signed and do not suffer any disqualification of use in proceedings later, unlike the statements given to the police. Anytime during investigation, if it appears to ED that it has reasonable material against the accused and it is necessary in the interest of justice to arrest the accused, then such a person can be arrested. The arrested person is produced before a metropolitan magistrate or a judicial magistrate concerned within 24 hours. And usually ED remand is taken, which can be for maximum 15 days, and thereafter, depending on the fact of case, judicial remand may be granted. On completion of investigation, ED will file complaint called Prosecution complaint with special court, which then will take cognizance of the offence without accused being committed for trial. Simultaneously, the ED will also file an application in the court where the trial of such accused may be underway in relation to the predicate or scheduled offences to transfer such trial to the concerned special court. After transfer, the trial of both the offences of money laundering and the predicate offence will take place before the special court following the session trial procedure. On completion of the trial, if the accused is found guilty of money laundering, he is submitted to the jail and his attached properties stand confiscated to the government of India. However, if the accused is acquitted, then the properties are also released back to him. So this pretty much wraps up the overview of PMLA. Hope we've been able to clarify your doubts. Thanks for watching. Stay tuned.